There are just very some small corrections.
No, I think this is 1501. Just 1 minute. The present batch of appeals are allowed. The judgment and final order dated 21st April 2022, passed by the learned single judge of the High Court, is quashed and set aside. Judgment and award dated 7 June 2007, passed by the reference court, is quashed and set aside. We direct that the compensation granted to the appellant be enhanced from 32,000 per acre to rupees 58,320 per acre. We further direct that all other consequential benefits of sonatium and interest on the enhanced compensation in terms of section 23(1)(a), 23(2), and 28 of the Land Acquisition Act 1894 be granted to the appellant. Pending applications, if any, are disposed of.
Please. But in this, it's very small.
In fact, you just want the inclusion of an FIR.
Yes, that one.
You have no problem on that.
No, that's
And Lord, now, politics stuff, it is the same, but Ramdev, they've done that, Lord. In the advertisement, pay very small, fine print kind of apology.
That's according, we don't know what the apology has done. We have passed an order, and given the details there. If that is a violation, that's a different matter.
Social media apology also has not come.
That will come, don't worry. Why rush to things?
No, it's still
Give her some time, everything will come, don't worry.
They don't follow the order, they know what is
The consequences are known, we have made it all clear in the order.
She's an IPS officer, so she knows.
Unfortunately, here also.
That's right. Therefore, I don't think, we don't think that
Your
we are
correction.
Dowry demand, they had agreed, Lord. That was not something, there was an issue, that without any dowry, the marriage was without any dowry.
Right.
That also.
That's not required if, assuming that would have been a dispute, that would have been solved. Hardly makes any difference when the matters are being settled, let it be settled now.
No.
Put everything on behind and move forward now, both the parties should.
Please,
There was no conflict.
we've already published the apology as well. Let's see.
That's good enough.
Great.
You have done that.
Great.
That's good enough. So the corrections which will be incorporated would be in para 4A, and we'll be adding 5, where instead of the magistrate, chief judicial magistrate, it will be the High Court of Allahabad.
That's right.
Please, Malak.
And in para 4C, we'll be adding this as 3A. We'll be adding it as 3A. The FIR, which is to be included. And then in the final paragraph 11, 7th line, where we have mentioned 1I to 3I, it will be 4.1 to 4.3A. That's what we are going to say.
Good.
Not to be deleted.
Well, it's 801 is coming up for tomorrow.
Coming on 29th, not listed.
If it can just be next week, that was my request, my lord. The mentioning has been put by the
Sir, I am
respondent.
for, your lordship, I am for respondent number 1 and I have moved a letter for non-deletion. It is coming up tomorrow.
If it could just be next week, my lord, I just have some personal difficulty.
We'll have it in the next week.
Next
Obligation.
week.
I think Mr. Gilla appears for.
Yes. That's the reason.
Your lordship, may I please mention item 8? Please, your lordship. Your lordship, I have been asked to vacate the premises. The matter may please
You have been asked to?
vacate the premises. I am a
No, but 802 is something regarding license.
Yes, please, your lordship. It's a railway matter.
Is there any interim order? Well, it is IRTC who is in appeal here. Anyway, next week,
Please, your obligation.
803, my lord, says that Forest Conservation Act matters. My lord, then it's compensatory for compensatory afforestation. Forest land, whether it can be used or not, my lords had indicated in the order it could not be done. But my lord, that's what's happening now. The MOEF regularly passing orders.
no,
My
it
lord,
can't,
yes.
it can't be done unless there is a certification by the Chief Secretary that there is no other land available.
Yes, my lord,
That's what has been held.
my lord, up to date, the meetings which are being uploaded are showing that forest land is being diverted. And my lord, this we had even prior to the earlier.
No, but is it done with the certification of the Chief Secretary or without certification of the Chief?
My lord, that is not clear. My lord, from the minutes which are uploaded, it is not clear. That's number one.
Give it to the green bench.
My lord,
I think we'll keep the green bench next week somewhere.
yes, next week sometime, my lord.
In this,
So Wednesday, I think.
yes. Well, in this matter, we have two IEAs. Malas, I am also environmentalist. Malas may list that also with the main matter. I'm grateful.
The same matter, we also, state also has filed an application that also can be listed for implement and also for clarification from
Which state?
Uttar Pradesh.
Deeply.
Now, all those matters from next week.
It's a land acquisition matter, my lords. Could it be possible to next week or second next week, my lords?
What is the urgency?
My lords, he is 78-year-old, my lords.
He is
78-year-olds, my lord.
28-year-old.
78.
Next week.
My lords, would it be possible to mid of the August, my lords? Mid of the August, my lords. It's also second similar kind of matter, my lords. Land.
Which one?
Please, my lords.
What did you say?
My lords, this one is also similar kind of matter, my lords.
Okay.
Please, my lords.
Obligation. 804.
वो सिमिलर है वो लैंड एक्विजिशन थे साथ में उसके लगा No, 805 और 804 similar है वो
No, this is the case.
not to be related. This is on 11th August.
No, they are in jail and the 3-year-old child, the girl child, not she is out. No, she is crying like anything. My lords were pleased to grant them bail, and 5 new cases were not added by the IO, and he took them in custody.
Okay, next week. Next Monday.
I was requesting for not to be deleted, man.
Not to be deleted.
These plots are 808 plots. I only mentioned plots for petition plots. But this is a not to be deleted letter plots. However, this is a not to be deleted letter. So the tentative date was displaying for today only. Plots.
Not to be deleted.
Plots may have it in the next week.
Not to be deleted.
Plots may have it next week. Not the date was displaying.
What is the urgency?
Urgency is not from last 1 year. I have been unsuited not because of color blindness. Because I was a
Please take the mic.
I was a constable plots with. I had to be recruited to State Reserve Police Force plots. From last 1 year, I am unsuited not because of color
Please
blindness.
speak in the mic.
From last 1 year plots, I have been unsuited for color blindness plots. I was be recruited as a constable plots with the State Reserve.
Okay, next week.
I'm so grateful plots.
Yeah, all good. All good.
Yes, madam.
It's very difficult for people to come in and out.
Let's Millets, I'm the farmer in this care for the felling of trees, millets, this 10-year management plan. Mine felling of trees was for 2023 to 2024. Now it's already 2025 to 2026 will be the last session, millets. Millets, the issue in this was that my village name was to be changed.
Sure.
But my village name, because it was wrongly mentioned Chuck Cheryl. And then millets, the authority has not changed it, millets. Millets, this IA is for the implement for the direction, millets, with your lordship's order, millets, the last of 20th of November 2024, millets, you have directed that the authority could be permitted to change all these typographical errors in the villages' names, millets. May you please see if the IA is there with you, millets, page number 68, millets. Millets, it may be listed, millets.
Lordships, 810 pertains to the pay scale of PRD Jawans. Lordships had directed it to be listed after 2 weeks in April.
So what is it about?
This pay scale of PRD Jawans. They are seeking equivalent of guard in Uttarakhand.
Next week.
Lordships, I seek your Lordship's indulgence to mention a matter. Lord, a review petition is coming up before my Lords tomorrow. Lord, the judgment originally was my Lord Justice Ram Subramaniam sitting with Justice Pankaj Mittal. Review is fixed before your Lordships tomorrow. My Lord, the Chief Justice and Justice Pankaj Mittal. Request is, Lord, for an open court hearing for this reason. Lord, 8 judgments are there which say that in a recusal order, the judge need not give reasons. The High Court, Lord, the judge, while passing an order, passed the order, and on the subsequent date said, oh, I made a mistake, I have appeared for a party. In the meantime, the order was challenged. When we pointed out this, Lord, the learned judge, the bench said that no, there is no order, reasons given in a recusal order. Therefore, how do you say? We said we have filed an affidavit on oath. It is not disputed by the other side. So, Lord, that matter is coming up. We want an open court hearing, 1005 tomorrow. And I'll give a note, Lord.
If I can, Lord, add, there are 2 reviews. I am mentioning the other review for the prayer is same.
Arising out of the same judgment.
Out of the same judgment, I'm sorry, the different judgment, but on the same issue, my Lord. In my case, my Lord, MA has been filed. In the MA, this Honorable Court has been pleased to issue notice and no precipitative action. And the grounds of MA and the review, my Lord, overlap, though it is filed by a different party. I have not filed the MA, some other party. But it is
in the open.
Lord, in fact, this requires, because it's also contrary to the 3-judge bench judgment by this Honorable Court in the same matter. But that is ignored, my Lord. I'm sorry to say, under the judgment under review. So, my Lord, it will call for an oral hearing, my Lord. If I can pass on this order where open court hearing has to happen, my Lord, on this.
Well, as I'm troubling your Lordships, mentioned.
Kindly see this.
This is some order, I think, because of somebody coming from this side, somebody coming from that side.
Lordship, may I mention?
Yes, Mr. Booth.
Yes, Lord. So, this is a fresh SLP against an order by which, Lord, my goods worth more than 4 crores are directed to be auctioned in pursuance of an eviction notice under the Public Premises Act, and that notice is also of 2001. And the person whose goods are there was a subtenant who came later and whose rents they...
Next.
Tomorrow, that auction is tomorrow. That auction is
You
tomorrow.
could have mentioned it earlier. When did you get the notice?
It was filed only on Saturday because the order is of 25th July of the Calcutta High Court. That's why, tomorrow. I am
That's
My Lords.
review petition, Lord, which I want to mention, Lord. This is a matter where 268 people were allotted houses, Lord, by the Telangana government in 2008. And that judgment now has been delivered, Lord, noticing some very wrong facts with regard. These are all India services people. And it has been noticed as if they are affiliate peoples of society. And in the same batch, Lord, they were journalists. That petition was separately taken out and they were allowed to, Lord. So we are only wanting, Lord, one of the judge, Honorable Justice Sanjeev Khanna has retired, Lord. So it should be listed.
Who is the other
Justice Deepankar Dattam. We are all...
Gujarat is also facing the same problem.
In fact, the Attorney General, Lord, Mr. Venugopal was asked to give suggestions. He gave suggestions also, even those were not, Lord, included in the final impugn order, Lord. We are also requesting for open court hearing, Lord, if your Lordship can.
Mine is more pathetic, millets. Unconnected with the whole thing, we purchased constables, police constables in armed forces. We purchased the land from the government 2008, paying 6 crores. Now, consequently, my GO was set aside.
Let the bench be constituted.
So, Lord, can I make one request, Lord, for some other matter, not this matter? Lord, I am requesting for Ministry of Steel. Lord, there was a directive issued, Lord, Ministry of Steel. Steel Ministry. Lord. Lord, there is a directive issued for the purpose of quality compliance that everything regarding steel should have quality compliance as per ISI standard. Lord, that is stayed by the High Court. Resultantly, the goods coming from other countries which are not ISI specified are now being powered.
Friday.
Lord, can it be tomorrow, Lord? Because we are facing contempt and goods are coming, Lord, from China and other countries. Lord.
Day after tomorrow.
Day after, Lord.
Lordship, by virtue of the order.
My lords, we have filed an IA in MC Mehta seeking permission for cutting of trees in the Taj Trapezium zone, my lords. On 30th May, this court had ordered the IA to be listed on 22nd July, but the IA did not come up in the cause list, my lords. MC Mehta is listed on 30th July. My lords, may kindly direct.
July को है कि 6 अगस्त को 30 July permission was saying that he is in follow. किसको है?
Lordship, by virtue of the order passed by this Honorable Court, Lordship, on dated 16th May 2025, this Honorable Court, Lordship, listed the matter on 29th July, but still, Lordship, the matter is not listed. The matter pertains to, Lordship, the challenging to the Mahabodhi Temple Act 1949. Lordship, the petition was filed in the year 2012, and Lordship, the notices were issued for final disposal in the year 2018. Since last 7 years, Lordship, the matter was not finally heard. Though, Lordship, twice this Honorable Court directed to list the matter for final hearing.
Have you given the note?
Yes, Lordship, I am praying, Lordship, my humble prayer that this matter, a fixed date may kindly be given in the next week.
Why don't you come through the regular mentioning process?
Because, Lordship, the matter is not listed tomorrow in spite of the direction.
At least give something on paper.
Listing in a, despite your Lordship's 100 judgments, a Singapore seated arbitration, Omani law, partial award in my favor, challenged up to the Supreme Court of Singapore, I won. Then a bias application, challenged up to the High Court of Singapore, I won. I got an anti-suit injunction from Singapore, yet the Delhi High Court has injuncted the anti-suit injunction. It's extraordinary.
When is the order passed?
I beg pardon.
When was the order passed?
Friday. You came to us on Saturday. Kindly, tomorrow,
Friday.
day after,
Friday.
Very well. It's Friday, I can't object.
Milord,
I give the direction of Friday. Right.
May I mention, Milord, can I mention a matter?
Yes.
It's a interim bail granted by my lords, expiring tomorrow. The matter was heard in the regular bench headed by Justice Oak, my lords, before the vacation. But during the vacation, it came before 2 benches and extension was given, expiring tomorrow. In fact, we moved for mentioning on Friday, my lords, it's not come. Can I request for tomorrow?
Milords, may I mention, Milord, I am a trust. I have given my land to Chennai Metro. Now what happened is Chennai Metro's land is already done. The sale is also concluded. A third party goes and challenges that order before the Madras High Court, and Madras High Court dismisses that first. The matter comes to this court. The court says decide within 2 months. Instead of deciding the matter, the court is passing injunction against me and is also asking for financials of mine, disturbing my entire thing. This order was passed on 18th of July. I took my chances on 24th of July. Again, the matter has been listed on 31st of July, seeking my financial and all restraint on my functioning.
Lordship, may I mention a medical admission matter where the merit list is to come on the 30th. The impugned judgment is of 24th July. I am born in Goa. I studied in Goa right up to 10th. Because I have not done my 12th from Goa, I have been sought to be excluded by the prospectors. So, Malaz, I am just requesting if the SLP could be tomorrow, Malaz. It's a fresh SLP.
Milords, mention of fresh writ, Milords. Milords, this pertains to Milords mass leave in the District Court Judiciary of Rajasthan, Milords. Mass leave, Milords. What has happened, Milords, is that a full court, Milords, 2 years back, Milords, had accepted a resolution for redesigning of the district cadre, Milords. This was pursued, Milords, even in fact, Honorable High Court of Rajasthan asked the government to implement it, Milords. It didn't happen. Milords, thereafter, with due intimation to Honorable High Court, Milords, first the staff went on hunger strike, and thereafter again with due intimation, Milords, to the Honorable High Court, Milords, they went on mass leave, Milords. What has happened, Milords? Mass leave by the district court, Milord, staff, Milords.
So we pass an order of contempt against the lawyers for boycotting the court.
Yes, Milords.
And the staff, which is a disciplined force, wants to go on a mass leave and stop the functioning of the entire court. They should be dismissed forthwith.
I bow down, my lords. I bow down, my lords. But this has been a.
You have a constitutional means of raising your grievances, but you can't take somebody at a gunpoint.
No, my lords. May I just explain, my lords? It was not at a gunpoint, my lords. In fact,
What is not going on mass grave? What is that?
yes, my lords. May I explain, my lords?
You could have raised your grievances. You could have filed a
It was
petition
raised.
challenging that decision before the
Letters were written to the Honorable Chief Justice, my lords.
tomorrow for dismissal.
My lords, and what happened, my lords, is that even
We are keeping it tomorrow for dismissal.
Lordship, last
if I may.
in fact, a
We are keeping
meeting.
it tomorrow.
Lordship, may I mention?
Better ask them to join.
My lords, we'll do that, my lords. We are not here. Not.
Otherwise, we'll ask the High Court to take disciplinary actions against all of them.
My lords, High Court has passed an order, my lords, where they have said they come under ESMA, my lords. We are not here to obstruct. We will join, my lords. We only need a meeting with the government, my lords. 2 years it has been pending.
So if you don't get a meeting with the government, you can't take the public at a ransom.
My lords, 2 years we are not taking, my lords. We'll join, my lords. We'll list it tomorrow. We'll show all the records.
If you don't join by tomorrow morning,
Because the matter is
we direct the High Court to take a disciplinary action against all of you tomorrow.
that order is already passed. We are up against that order only, my lords.
Then we'll dismiss it simply, sir, tomorrow.
Lordship, may I mention one criminal appeal?
Petitioner is a senior
That's tomorrow.
citizen. On Friday, he was
Keep you
asked to
obliged.
surrender. Interim Interim accident for tomorrow or day? Apologize.
One can, we can hear only one.
Lordship,
I made a mention, my lord, my request be considered.
The day after tomorrow, not tomorrow.
Lordship, may I mention one criminal appeal where the petition appellant has undergone actual 17 years of sentence. His appeal was directed in 2022 to list after 2 weeks. Till date, it has not been listed.
My lords,
Lords, may I mention one IA? It is in 13029 of 1985, Fred petition 13029 of 1985. We have filed an IA for clarification that whether the 10-year, 15-year vehicle ban should be applied retrospectively or prospectively, and whether the age should be associated with the pollution.
NCR of Delhi,
Yes, sir.
National Capital Region.
Yes, sir. So today, this matter, the similar issue is listed.
Today,
Yes, yes, my lords.
we'll keep it, take it along with that.
My lords, petitioner is the woman of a 13-year-old child, my lords. She has been arrested under Customs Act in utter violation of the law as laid down in Radhika Agrawal and Arvind Kejriwal, my lords. My only request is to list the SLP tomorrow, my lords. The High Court has refused to interfere in this. No reasons to believe or necessity to arrest was there, my lords. Only request is that it could be listed tomorrow.
Day after tomorrow.
My lordship,
My
the
lord.
petitioner is a senior citizen. On Friday, his extension for interim bail was dismissed without perusing the medical records. My request is for tomorrow, he'll be incapacitated for life.
Day after tomorrow.
For tomorrow, your lordship.
Day after tomorrow.
my lords, may I mention? My lords, in 2016, I filed a criminal complaint with CJM against the SP Assam.
2012.
Sorry, my lords.
2012.
Uh,
In which year you filed a complaint?
2016, my lords. I filed it for assaulting and outraging my modesty, my lords, when I went to personally serve a summons in another matter. My lords, the cognizance was taken in the matter by ACJM. However, the High Court has set it aside on the ground that sanction under 197 CRPC was necessary. My lords, I am praying for listing before the court because as per the last order, Honorable Justice Bela Trivedi directed it to be listed in the last week of July. However, my lords, it was tentatively shown on 29th.
It could have come through a regular mentioning process. It's not as if that
Because I tried that also. However, the registry did not take it, stating that the matter is shown in the last week of July, so you wait till then. Milord, it was shown in tentative list of 29 came.
Who told you that? Who told you that?
Sorry, Milord.
Who told you that? You said that.
Mentioning branch. I went to the mentioning branch. Milord, I specifically gave a mentioning for not to be deleted.
Last week of July is this week.
Milord, it came in the advance list of 29. It did not come in the final.
You come through the mentioning process.
Please, my lords. This is a shocking case of political harassment, my lord. I was arrested in January 2025. And despite my securing bail in every pending case, every time I secure bail, a new FIR is filed and I'm taken on remand the same day, my lord. This is in the state of Andhra Pradesh. I'm an opposition party member. I had mentioned this matter on Friday, my lord, and listing for today was allowed. However, unfortunately, it's not listed. I request it to be listed tomorrow.
You did not cure the defects. You did not cure the defects. That's why it is not listed.
I apologize. Now we've cured the defects, my lord. I'm told on Friday, Saturday we've cured the defects. I request tomorrow, my lord.
Or day after week.
Most grateful.
Great, please, Lords. Transfer petition. There are two suits The one suit is in the Madras.
Your suit is prior in point of time.
Yes, my suit is prior in time. It's decided against me. On the strength of that decision of the single judge, the assignee approaches the Bombay High Court against me. And that matter is pending. The injunction application there is being.
What has happened to your suit in
my suit? I filed an appeal to the division bench. The division bench stayed the single judge judgment which assigned the rights to that assignee. So it's inextricably linked. That specific proceeding which has subsequently started in Bombay should be transferred to be heard in the same place. In fact, the Bombay single judge has observed that it's virtually res judicata because it's already covered by the assignment issue in Madras. Wait.
Lord, may I just give you a question? So his suit was dismissed on 4th June 2019.
On?
4th June 2019. Just 3 dates. 4th June 2019, his suit is dismissed. I filed my suit on 12th of January 2022, on which date no proceeding in Madras is pending. That's first. Now, in my suit, I will not say copyright infringement of 536 title albums. He is not concerned with all 536. He's not concerned with all 536.
He's concerned with how many?
I'm 536, out of which 250 are outside his repertoire. He's not concerned with that at all. My defendants are different, his defendants are different. After I file my suit, he files an appeal after 4 years to counter my suit.
So all the parties are not common in both groups?
Not common. See, 2 pages, the parties are not common. Right? Parties are not common. So my 536, in which I'm claiming a copyright infringement of somebody other than the petitioner here, those defendants can't go there. Defendant number 2, which is the music company in question, that is infringing my copyright. And there
So you are the respondent number 1 here.
I'm sorry, I'm Sony.
Yes, that's respondent number 1. No?
Yes, correct. I'm the original plaintiff in Bombay, and when I filed my suit, for 536, there was no proceeding pending in Madras. The Madras proceeding had ended against the petitioner. Suit was dismissed. After I filed my suit, the appeal is filed to counter me.
So, I don't know how many, 536.
536.
Out of them, he is concerned with how many?
314.
310. 310.
314. In Bombay, 314.
And the rest of them, sorry. Now, what happens is
you are saying that the Madras High Court has stayed the.
Correct.
But your suit is dismissed.
Yes.
So
how can there be a stay of dismissal of a suit?
There were multiple suits. The final direction that the Madras High Court gives is with reference to the rights which are given by me to my assignee, who is ECHO. The suit filed by Sony admits that on the strength of the Madras High Court decree, ECHO gave it to Oriental, Oriental gave it to Sony. That's how Sony gets the rights. That's what their own suit says. I don't think they'll deny it. So their suit, while there are other people against whom they have some copyright issues, 314 works are my works, which they can claim only because of the Madras High Court decree. I hope I'm making myself clear. Without the Madras...
What were you doing for last 3 years?
No.
They have filed the suit on 12th of January 2020.
Correct.
When were you noticed?
I just want to show you, Your Lordship.
So when were you noticed in that suit?
My friend is right on that. That the 2022 appeal that I filed is after 1 month after his suit in Bombay. That's correct.
Filed the suit on 12th of January 2022.
Correct. And I filed my appeal in February 22. I'm not running away from that. That's a fact. But subsequently...
No, but when did you receive notice in a 2022 suit?
When did I receive Bombay notice? Bombay.
The next day after.
Just give me a half a minute. I'll just check the date. I don't want to.
My instructions are next day. These are mine after the fact.
Next day?
Yes.
Bombay High Court suit date. When did I receive notice?
After counter, that's no.
But subsequent. I'll just check the date. I'll just get back. It.
Just ask tell us to give the date.
No, but I want to.
Second week. So can I say one more thing? Can I say one more?
One minute, let him. Or at least tell us the date when you are putting your appearance before the Bombay High Court. Tell us the date on which you have put your appearance before the Bombay High Court.
That was February 22, and there was no delay because of COVID. Because of COVID, Malad, there was no.
Thank you.
February 22 is the date.
Thank you.
Very well. I'm grateful.
Your Lordship, this is a very peculiar case in which the accused has not been produced before the magistrate from last almost 45 months, Your Lordships. No cognizance of the charge sheet, no framing of charges.
4 years.
Not produced from jail for a long time.
Then we have passed orders deprecating your practice in Maharashtra of not producing the accused on time in the prison.
From last 55 months, Your Lordships.
We are asking him something.
Sorry. Apologies.
Lordship, there is some progress on that front. The meetings have been taken.
What do you want to say in the present matter?
Lordship, regarding present matter, there are two statements of two victims. Both victims were minor. He was a tuition teacher, and there are multiple incidences. He was arrested in 2021, 1st of November 2021. Charge sheet is filed, charges are not yet framed.
What was the age of the girls?
Both were, one was 15 years. One, page 39 is the statement of victim, and the other one was 16 years.
Petition is vehemently opposed by the learned counsel for the state. However, taking into consideration that the appellant is behind to the past for almost 4 years, that even the appellant has not been produced before the court for framing charges, we are inclined to allow the application. The application is allowed. However, it is directed that the applicant shall not make any attempt to influence the witnesses and shall cooperate with expedition for the law trial. In addition to the opposite, he is directed to be released on bail. Such terms and conditions are given fit by the learned trial.
I'm grateful, my lords.
My lord, I am appealing for the petitioner.
उसके साथ what is stacked at the other matter.
I have served the standing counsel.
I'm in the next one.
3.1, ma'am.
What is stacked with the connected matter?
Direction to serve the standing counsel.
Yes, that is all format order.
Yes.
I have been in custody for 1 year now. Number one. The meanwhile, that's 32. Let's wait there. Where is my petitioner being? Where is my petitioner? Someone might be for the fallen stuff. Now, there are 32 others who have 32 accused persons. Not other 32 co-accused.
Notice returnable date is
My lord,
ready to solve the standing of.
my lord, as early a date as possible.
Yes, 3-4 weeks. Yes.
My lord, we'll serve the we take dusty.
That's a format here. Solve the standing. You don't take serve the standing counsel for the.
Obliged.
May it please. It's concerning sand mining in Rajasthan. There's some very clear guidelines which have been laid down and a mandate that has to be followed. before you.
But there is a detailed judgment passed by me in the case of state of Rajasthan.
We have annexed all those. That's why these matters are all pending here. As far as Rajasthan is concerned, they are already granting and putting out auctions for these sand mines. So what they shouldn't be doing is issuing any auction notice.
The DSRs are not done.
None of these preliminary processes have been followed. None of them, including replenishment study, the district survey reports, none of them. None of them have been followed, as a result of which we have depletion that's completely being done mechanically.
The 24 policy framed by the state of Rajasthan, so far as river bed sand mining is concerned, is permitting the leases to be granted for mining without conducting any study, preliminary studies, and without even conducting district survey reports. Issue notice, returnable 4 weeks. Everybody to serve the standing counsel in addition.
I'm great. I'm great.
Please, my lords. This is a petition under section 11. Seeking
Notice done maybe 4 weeks when you saw that.
3 months.
3 weeks just to permit.
My lords, there's a minor delay in refiling. May I request that the delay be condoned, please? There's a minor delay in refiling, may I please? So great.
Please, Your Lordship, the issue at hand pertains to a questionable construction being done.
Yes, it has been found to be beyond 550 meters. There is a buffer zone. There no trees have been cut. There is a valid permission of the competent authority, that is the municipal corporation. And who are you?
Your Lordship,
Who are you?
Your Lordship, I live nearby the concerned land, Your Lordship. If any environmental damage is caused, I will be clearly affected, Your Lordship. Your Lordship, the main contention is.
Appears to be you have some rest to grind against the respond number 8.
Your Lordship, if we see the impugn order, Your Lordship.
So the impugn order has considered everything.
Your Lordship, the impugn order is contradictory in nature, wherein the second.
Because the committee was appointed, the committee has conducted spot inspection. The report is obtained.
Your Lordship, I agree that there is a.
Thank you.
But
Thank you.
Your Lordship, I am requesting to withdraw the petition.
Not to withdraw.
Excuse me. Item 10 has become infructuous, will it? Nothing survived. Lord, if I can only request, if your lordship should only request the High Court to decide, because every year such applications are made, and
then the High Court has relied on its earlier order.
That is also an interim order, my lord. The main writ petition is still pending before the High Court.
The petition is referred infructuous in as much as the Bakri, for which the permission was granted for annual sacrifice, is already so. We are taking into consideration the sensitivity of the matter. We would request the High Court that rather than passing interim orders, to take up the main petition for hearing and decide it in accordance with law, at least before next such incident arises.
I am grateful.
That's it. Tag for the notice tag.
Lord, we've been caught in a logjam. We in COVID gave our land for building a confined facility. After
12.1.
We're in 12.4.
We're appearing in 12.1.
12.1 below.
12 and 12.1 is the same. I am in 12.1. The lordships are right.
You are in 12.
Lord, I'm in 12.1.
You are in 12.
But I am in 12.1. My benefit perhaps
12.1. We're in the same matter, my lord. The issue being that my project has not started, there's no issue.
He has started.
Yeah, whatever.
Lord, Anyway, my lord, the problem here is this, my lord. During COVID, my lord, I gave my land to the state of Maharashtra, my lord, for building up a
You
corridor.
give us 50% of the land.
Yes.
You give 50% land, and 50% was to be returned to you for construction of a housing scheme.
Because the state of Maharashtra, my lord, on 50%, they wanted to build an under the
For low income group.
yes, some houses. It's vacant. The concerned authority, my lord, seems to be under some impression that because of the lordship's judgment, this is like a post facto EC clear.
Yeah, because the judgment clearly says that no permission shall be granted after that date.
Taken. If I had construction and then gone for clearance, the judgment would have come in the way. They seem to. Now, please see page 80 for a moment, you know. Please see page 80. Now, what is, my lord, which has lines, my lords would see, that is the land which is vacant and which is with me. The other land I have given to the Thane Municipal Corporation, my lord. Now, under the.
Whether the Thane Municipal Corporation has undertaken construction for low income housing scheme.
I don't represent them, whether they have not, my lord, that is one point. As far as I am concerned, this vacant portion, my lord, surely they're entitled to, sort of, I'm entitled to go and ask for an environment clearance, my lord. Had I constructed, this judgment would have come in the way. Now, my lord, please see page 111. I have applied to.
Had you got the permission prior to the date of the judgment, you would have been saved. Because this court protects all such permissions granted by that particular date. And it quashes the OM from prospective effect.
Correct. Lord, I applied prior to the judgment, my lord. Please see page 95, my lord. Please
Because the judgment doesn't give reason as to why it is being done.
Sorry.
The judgment doesn't give reasons why such an order is being passed.
Correct. Yes. Now,
Whether the Union of India has an authority or not, whether the Union of India, MOEF has a machinery to, the only thing is maybe post facto sanction we can understand, but some reasoning ought to have been given by.
Correct. My lord, they give me a.
Anyway, we will issue notice. Yes, Mr. Almi.
Yes, Manoj.
You are appearing for MOEF, ma'am.
Yes, Manoj, I beg to appear.
Your stand would also be necessary.
Yes, Manoj.
So it is your OM who has been passed and set aside.
Manoj, these same submissions were in fact made during the course of the hearing. And
What are the reasonings given by the division bench?
Manoj, as far as
as to why it is being done?
Manoj, as far as your lordship's judgment is concerned, Manoj, that
No, we appreciate the concern for the environment, but how these OMs are likely to affect the environmental balance, and it doesn't speak anything about the sustainable development.
As far as the SOP and
because nobody is in review.
Manoj, there are two reviews. In fact, my friend has also filed a review. It's there in the office report.
He is only seeking an IA since everything was done prior to the date of the order of the High Court.
They've also filed a review, which is there in the office
That was
report.
lying in the registry, wrongly advised, my lord, because there is no construction here. Nothing has been done there.
Anyway, we will show this. Let the state of Maharashtra come.
And if my friend says, Manoj, that there's no construction, then perhaps he's not a violator. Take as a
If there's no construction, then
yes, then he's not a violator. Then
he is caught in the fix. The government of Maharashtra tells him that because of the judgment they can't do anything.
With great respect, if he has not violated, then these OMs even otherwise don't help him. But we can independently apply for a clearance.
Let us consider it.
Because then it would not be an ex post facto clearance, Manoj. It would be a prior clearance, prior EC as required by law. And
It's a complete impasse which has been created now.
You are appearing for who, Mr.
Same IA.
Same party?
Yes.
Same IA. We only permit one council to argue for one party.
Would your lordships kindly also permit us to impede the environmental assessment authority also?
CI?
Yes.
I think the CI has already cleared you.
No, my lord. They gave us. I got a commencement certificate and a letter of intent, my lord, that I can apply for an EC. I didn't impede them because the registry says first notice if it is issued.
Yeah, leave to impede the parties. The amendment will be carried out during the course of the day. Show notice. Interval 3. Dalmia, the Senate Council bears notice on behalf of the original petitioner. Ms. Aishwarya Bhatti along with so and so bears notice on behalf of the MOEF liberty to serve the standing was the state. Leave to serve the state good standing also.
Please.
12, there are 2 IAs and there is one more for clarification which has not been listed today. That is 144-825 and 824. Now, my lords, here also, my lords, in our respectful submission, the order is silent. And what is to happen in cases like ours, which we started in 2014, we applied under the window which was given.
No, because an anomalous situation, everybody who has been granted permission till the date of the judgment, irrespective of violations, has been protected. And the cases like him, wherein everything was done, but because of some factors beyond their control, they could not start the construction, they will not be.
In our case, my lord, SC
Anyway, you give the number, we'll list all those matters.
As far as this case is concerned, in fact, the observation by the.
So, Jalmi, what are the reasonings given in the judgment?
Because I'll show you lordships. I can show you.
I have gone through the judgment. Anyway, we'll hear you after everybody is here.
We just give our number.
Yeah.
Well, this is really very surprising.
Yes, we'll issue notice.
State.
How can it's a more than a settled law right from Indra Swani that the executive has the power to do it?
Their own act which says, Vinod, and the High Court earlier judgment says.
No, but the Supreme Court 9 judges bench says that the executive can do it even by an executive instruction. There is no legislation necessary for providing reservation.
Oh, no doubt about that. But they have made their own act in 2012 which says otherwise, that it will be done under, as per the procedure under the act. They are doing it under the 93 Act, Vinod. And Vinod, they are not filed counter. The High Court wanted to hear the matter.
Because I am really surprised what my learned friend is saying, Malats.
We'll stay this order.
Yes.
And if you want, we'll direct the High Court. One minute. We'll direct the High Court, we'll request the learned Chief Justice to direct the matter to be placed before some other judge.
I'm not,
it's surprising.
No, I'm not joining any issue on that. But what I'm respectfully saying is, Your Lordship may not state today. There was one time.
40,000 teachers to be appointed, no promotions to be made, roster system cannot go on.
How can the executive just show the reasoning given by the High Court?
The reasoning is at page 11 and 12.
Come to para 16.
Yes, Vinod. But para 16, Vinod, may I place it, Vinod?
Yes.
Yes, please.
Directions contained in clauses 8.
No, para 16 of the impugn order.
Yes, Vinod, I'm reading para 16.
The state ought to have placed.
Para 16.
There are two 16. The learned judges even forgot to correct the paragraphs.
Para 16.
Okay.
Para 16 is at page 11.
It is also at page. It is also at page 12.
My mistake.
Yes.
My mistake. I stand corrected. The Lordship are putting the second para 16.
No, you want the first para, read the first para 16 also.
Not entirely. My Lord wanted me to read that. No,
you read your paragraph 16 first.
Lordship, please. Yes. The directions contained in clauses 8 to J in paragraph C61 need to be considered together and not in isolation. A particular line cannot be picked and highlighted. From the said directions, it is explicit that we have read down the expression Government of West Bengal and the government to mean the state of West Bengal in discharge of its legislative functions. We have also struck down section 16 of the Act since it empowered the state executive to amend the schedule and had consequently down 37 classes included in the exercise of section 16 of the state executive. We have also struck down section 5A of the 2012 Act, which distributes the percentage of reservation in 10% and 7% to the subclassified classes. However, prima facie...
Now, in the teeth of the 7 judges bench, that subclassification is permissible. Now, read it further, yes.
This is only about the judgment, my lord, which matter SLP is pending before my lord.
No, here he said that he want, I think that SLP is not pressed.
No, your lordship, what happened?
It's very much pressed.
No, they were pressed.
They were pressed, they have only said that we are. doing another
Allow.
something. What they said.
Okay, let us complete the reading of this paragraph.
Yes, my lord. However, prima facie it appears that respondents are proceeding in hot haste and are attempting to bring in the self-same classes and to reintroduce the percentage of reservations which have been struck down by this court by executive orders and not in exercise of state legislative functions, and that too before we can scrutinize the steps taken by the commission in terms of our earlier order dated 6th May. Well, my friend Milord had said on the last date of hearing in May that we are doing a resurvey now and we are going to have after fresh survey, we will come out with the list and inform so your lordship put it in July. That's the last order, I can place that immediately. But that my friend did not say at that time that he's not pressing his SLC. The SLPs are very much pressed, my lord, but the your lordship declined to grant any stay there. Now, my lord, the second para 16. The state ought to have placed the reports and the bills before the legislature for amendment and introduction of classes in the schedule of the 2012 Act. The executive notifications are in direct conflict with the judgment and the same had not been issued under the 2012 Act. I'll show the notification just now. This court had categorically observed in the said judgment that it had not interfered with the executive orders classifying the 66 classes prior to 2010. The said judgment had not been interfered with by the Honorable Supreme Court, and that as such there can be no hindrance in conducting the recruitment process as well as the admission process, taking into consideration the 66 classes of OBC as existing prior to 2010. So those people who are prior to 2010, they can be recruited. There is no problem at all. Now, my lord, for the reason, therefore, the stay. Now, my lord, may I just show one notification, my lord? If your lordship will kindly have with me, my lord, volume 3. My lord, volume 4, my lord. I'm so sorry. My lord, there is a volume 4 that they have annexed, my lord.
Sure.
Your lordship may see this at page 1267.
What's wrong with this fine?
It is from pages 1118. You will see in the top, pages 1118 onwards.
Triple 18.
No, but it starts from 1118. I am at 1267. But I'm sorry, Lord. I was just wanting to the court to help the court master. That is the volume, Lord, which starts because the volume number is mentioned right in the foot of the page. In the index. May I place this, Lord? 1267.
Yes.
This is the gazette dated 10th June. Now, my lord, below that, your lordship see so and so number dated 27th May. Whereas the backward classes have been defined in clause A of section 2 of the West Bengal Commission of Backward Classes Act, where so and so, to mean such backward classes of citizens other than the scheduled caste and scheduled tribe as been specified. Whereas lists have been defined in clause C of section 2 of the said act to mean lists prepared by the government of West Bengal from time to time for the purposes of making provision for the reservation of appointment of posts in favor of backward classes of citizens, which in the opinion of that government are not adequately represented in the services under the government of West Bengal and any local or statutory.
This has been stayed, Malad. I don't know why my learned friend is reading it.
Therefore, my lord,
All have been stayed.
with all due respect, my lord, your lordships are saying to stay this order, the order of the High Court. Therefore, my lord, I am trying to show why it was stayed.
What?
My friend, my lord, observe, my lord, that we will stay this order of the High Court. Therefore, my lord, I am placing it. I can, lordships can keep it next Monday.
For what?
File a short affidavit.
Have it next Monday.
Yeah, and lordships are issuing
In the meantime, there's a stay, Malad. There are contempt proceedings. Contempt proceedings are pending. 9 lakh seats have to be filled.
Provides that the resolutions cannot be provided by executive instruction.
No, the statute sets out the, can I, my lords? The statute sets out the procedure. This issue was raised in round 1, my lords. They said, where is the question of insisting that only a law can be made? We argued, therefore, pointing out to the court that there is no impediment under 16 to make to provide for reservation without a law. But if a law is made, then, my lord, the state is bound to follow the rigors. My lord's judgment in Ram Singh squarely covers it. In fact, the Union of India, my lords, in Ram Singh's case, raised precisely this argument, saying that why should I consult the Backward Classes Commission? Why should I ever go through any procedures? 16 is an independent right. They relied on Indira Sani. Indira Sani was referred to. My lord still said in Ram Singh, yes, you can make reservation independently under 16. But the moment you make a law, then you have to follow the rigors of the law. That's point one, my lords. And this is
again, they are not telling
no,
the
my
fact.
friend would bear me out.
Section 16 is struck
No, my
down.
lords, I'm sorry, my lords, he should not interrupt, my lords, with great respect.
Struck down earlier, my lords, is reading section 16.
Bear me out, my lords. This is a very crucial point. This is a red herring they are raising. This is clearly a red herring, my lords.
Section 16 is struck down. 340.
And one more thing, my lords.
342A, my lord, 3 gives you the power, gives the power to the state government, my lord.
See, give me the new act.
Can we have
New act. Give me the new act.
Act, my lord, at page number.
We'll show, there's one more thing I wanted to say, my lords. We'll show 16 also. One other thing. So based on Ram Singh, there is a full discussion in the earlier judgment saying that now that you have made a law, you follow the procedures. My lord will also recall number of states have made laws. Tamil Nadu, Maharashtra, UP, various other states. In fact, Tamil Nadu, my lords, went to the extent of wanting to place it in the 9th schedule itself. So once a legislative rigor is brought in by the state itself, then it can't sidestep, my lords, and say, I have power under 16. And this precise, and they passed the law in 2012. They tried to provide for reservation under the 2012 Act without consulting the West Bengal Backward Classes Commission. Therefore, it was struck down. They came before my lords. My lords heard the matter and did not give them a stay. At that stage, they come to my lords and say, no, I will make a fresh survey of all the classes. What to do at that stage is take out, my lords, only that 112 or 113 which has been set aside in round 1. Same thing, my lords, they reintroduce in 1.5 months' time. Now have a look at 16, my lords, 16 of that act. Just see that, my lords. Yeah, that's correct. This.
On based on interim reports of the commission just now. There is no final report of the commission.
16, my lords.
Survey is continuing.
The state government, may I read that?
I know.
The state government may, by order published in the official gazette, add to, amend or alter any schedule. So,
power to the state government.
This was struck down. What? Can you just?
On what ground this has been struck down?
No, please come to 2H, my lords. Please come to.
Last time also your lordship asked the same question when the matter came up.
Please come to this, my lords. At page.
What is the procedure prescribed in this enactment?
Now, please come to that, my lords. Please come to 2H.
2H?
Yeah, 2H, my lords. First is the definitions, then I'll show the other provisions.
Yes, sir, it's specified in this thing. By notification.
Other backward classes, my lords, got that? May I read that, my lords? Yes. Other backward classes shall mean such classes of citizens as specified in Schedule 1 other than scheduled castes and scheduled tribes and include such classes as the state government may by notification.
So again the power is going to the state government?
No, there, my lords, there, here the latter part was struck down by the High Court saying that it does not provide for consultation with the Backward Classes Commission. And that order has not been stayed by my lords. That's part one, my lords. Indira Sani, my lords will recall, specifically requires that Backward Classes Commission must be consulted. The entirety of the exercise.
No, it also requires that a data has to be collected.
Exactly, my lords.
So whether the data has been collected by
no, my lords, I'll show their counter now. Now, please see their counter.
Data has not been collected, Lord. It's only an interim report given. They are saying themselves in the notification that while this is continuing.
Well, as I'm
just have a look at 597, my lords, the counter of the Backward Classes Commission. Just have a look at, my lords.
May I have a word?
Just see, my lords. Please see page 500.
597.
Please see, my lords, page 597. Volume 2, my lords. Please see, actually, my lords, the document which itself started, my lords, in 596. This is the Backward Classes Commission's document. Now, please see what they say. They are saying that they will do a sampling exercise. That starts at the top of 597.
Challenge.
Propose sampling methodologies for selection of households for benchmark sample survey on backward classes in West Bengal. My lords got that? Then, my lords, the methodology is given. I will not trouble my lords with the methodology. But what is important is after
identification of backward class population.
No, please see. Now, please see the third para there. As the data, my lords, get that para? As the 597.
Yes.
As the data on the population and estimated population of each class in the state could not be made available by the backward classes welfare department and could not either be obtained from any other source, P here may be considered as 50%, that is 0.5. They don't have data. They simply take a sampling method and say, I will use a formula and decide whether a class is backward or not.
This is done by the commission.
This is done by the commission. Today, that is that report which they want to sustain. What they are trying to say is this, my lords, the commission has given me a recommendation.
This is, he's reading the previous order where I told your lordships, we'll go back to the commission. Commission has done that exercise. That is here. He's not even referring
No, I
right.
want more.
One second.
That is at page number?
Page 791, not challenged in the High Court. Not
benchmark
challenged.
survey itself
That's
has been
not the
challenged.
High Court finding, my lord. Now let me say what you're just completely, with the greatest respect, not telling the facts to the court.
Affidavit filed in the
One
High
second,
Court.
just hold on.
I'll show the affidavit filed in the
Hold
High
on, hold on. The High Court judgment doesn't proceed on the basis that the commission has not done that exercise.
Of course, yes, the High Court says.
Where is that
nothing
order?
stays.
Where is that finding?
The whole thing has been done in post states. It's the specific finding.
No, see, mother, 791. The whole exercise has been done. It's all done. 76 have been added. 66 should. All that done, not challenged. That's not the finding of the High Court. When staying this matter. And this is just one community. There are many like this.
So one more thing.
Well, 1 week. In the time,
No,
it
sir.
will be stayed with the impugn order.
Look, just one more thing I want to.
We had in the next.
No, I understand, but just one more thing on this. On this
If
thing.
you are willing, we will direct the High Court decide the matter within a stipulated period. Till then, the status quo shall be maintained and the matter will be heard by the bench, not consisting of the learned judges.
Your lordship if your lordships are giving a status quo, my lord, we have no problem, my lord.
No, what?
The proceedings would proceed.
No, status
No,
quo.
we are not, there's no contempt which has been pressed, my lord. In fact, it's been adjourned. There's just one other thing I want to show, my lord. Just before on
They
this.
are against us now. There's a contempt matter
Just
pending.
one minute. Within 7 days of the counter of the commission, the counter of the commission in this very proceeding, the present proceeding, 1341 it starts. At 1346, my lord, just volume 4, my lord, just have a look.
Volume 4 there. Yes, volume 4.
Volume 4. 1341.
Commission has not filed any affidavit.
They have filed, my lord, 1341. There's a reply affidavit filed by them. 1341 at 1346, my lord.
Saying what?
My lord, have that para G. Subsequent to the filing of the said SLP in or about October, November 20. Para G, my lord.
Para G at 1346.
1346.
Yes.
Now, subsequent to the filing of the said SLP and in or about October, November 24, the Commission received a series of fresh representations and applications from various communities and groups, including 113 classes, addition of which were set aside by the judgment dated so and so for the reasons contained therein, and 4 new communities. Through the sets fresh applications, concerned classes sought inclusion in the state list of backward classes, primarily on the grounds of socio-economic backwardness, etc., etc. Then, please come straight away to 1354.
1354, para R.
Para R. Thereafter, the 461st meeting of the commission held on such and such a day.
Para?
R,
my
lords, at 1354.
1354.
Yes.
Now the members methodology of survey, my lords, are there.
Yes.
The members of the commission deliberated upon the methodology of the survey proposed by so and so and so and so. It was discussed and agreed that survey is opposed to a census and the two cannot be mixed up. A survey on its own means general consideration of something, appraisal. This can be done by competent statisticians or agencies opposed to a census, which is only done by the Registrar General. 93 Act also does not envisage a census or survey of the whole population for the inclusion of classes in the state instead of OBCs. There will also be an absurd and unworkable proposition that every time the commission is considering inclusion or over-inclusion, exclusion of one or multiple classes, it has to embark on a survey of the whole population of the entire state. An exercise so large as a scale could only be done logistically in a census by the central government. In fact, conducting a full-scale census would not only involve exorbitant financial costs, but may also delay timely policy intervention. On the contrary, a survey allows focused data collection and is administratively feasible and also economically prudent. Having regard to this, the commission resolved to conduct a survey using the Cochrane's method for sample size determination of the whole population, which is a universally accepted statistical method. Please read this with 597, which I read out, my lords. They don't do a survey at all. They give, my lords.
They do the survey, that's what they say. They are given the methodology.
They have not, my lords. They have just, my lords, simply taken.
Issue notice. In the meantime, there shall be stay to the issue notice.
Well, then we can continue with our promotions and everything.
We are not saying, we are saying that there shall be stay to the issue notice.
Well, let it be heard by Malad, I would suggest.
We don't know, otherwise I will have to assign it to some other page.
Because
once we start with the reference.
Well, what happens is, Mother, they're moving in contempt now, Mother. That's.
When we have set that order, no? We have set the order. No. If you are willing, come with the proposition, we'll.
If your lordships are asking the Honorable High Court, requesting the High Court to not consider the matter and decide within a certain time.
Yes.
And in the meantime, status quo will maintain.
No, in the meantime, we don't want whatever is there. If the commission has followed some methodology, which may be correct or not correct, that will be decided by the High Court finally.
But Lord, if your lordship stay the order and then they will just make all.
Yes, they will stay the order. Prima facie, the order is totally, patently erroneous. Thank you. Next matter.
Deeply observed.
You want, you mentioned the matter, we'll request the High Court to decide it within 6 weeks, 8 weeks. We'll request the Chief Justice to constitute a special bench, except the learned judge who is presiding.
Because my lords have heard it in a bit, my lord. We'll argue, we'll attempt
to
argue
it, but we don't know when it will come up. Because or otherwise I will come.
Next week.
Returnable 1 week.
Once the presidential reference starts, then we don't know when.
That's true. But now that we have heard that, my lords have heard us at some length, we'll argue.
With this argument, I think even the first order will go.
Lords, we are sure, my lord, we'll be able to convince my lords to agree with us.
Let us see who convinces who.
Lordships could keep it on a Friday, need not be on a weekday.
No, Fridays are not for such matters. Mr. Shukla has already gone out of the court.
This matter after notice. I'm saying this would be after notice, Lord.
Yes, it will be after notice. It will be on either Monday or Tuesday. Yes.
On Monday or Friday or something like that.
Not Fridays. Fridays are not for.
Sorry. Sorry.
Very well.
So Monday, Monday week or.
दो हफ्ते के बाद Monday को रख दीजिए.
Very well.
Lordship, grateful. Liberty to file small counter.
Yes, whatever you want to file.
Please.
My lords, in item 14, we are led by Learned SG. If the matter may be please.
Learned SG?
Yes.
For whom?
For the Union of India.
Item number 14?
Yes, your lordship.
Now, not touchy about somebody who was killed through dacoits.
Yes,
if you want the learned SG to come, but then it will be dismissed with cost.
Your lordship.
Now, if it is dismissed.
Your lordship, there's
don't make ego out of all this such small things. He has served the country. He has at the risk of his life, he went there.
Yes.
He has received bullet injuries, and you are just delaying. You are just refusing to award him gallantry award only on the ground that he has come delayed and all that.
Your lordship, that is the acting.
If you want, we'll keep the question of law open. But if it is dismissed,
if you
in the presence of SG, it will be commensurate with the status of the SG. Cost will be commensurate with the status.
Your lordship, if you may pass it over.
Our option is yours. You may very well tell the learned SG that this has come from the court, that if it is dismissed in your presence, it will be without cost
if I
If
may
it is
just
dismissed in the presence of LP,
why?
it will be dismissed with cost commensurate with the status.
Your Lordship, if I may just indulge
No, no.
for some time, if I may just take
No,
you.
no, sorry. Just making ego of.
No, Your Lordship, the issue is that the order that is being passed is to ensure that the award is given. And so the union is
Give that award, somebody else
But Your
was willing to sacrifice his life for the citizens of this country.
Your Lordship, there are some. So Your Lordship, firstly, that the thing is that these awards are generally given following a due procedure. So state has to apply, send the proposal to the union. Ministry will evaluate. They will go through the documents. They will forward it to CPAC. So there's no reservation in reconsideration. The problem is that such is against such direction, Your Lordship. This will have some serious consequences.
Tell the learned is. Therefore, we are saying that we'll keep the question of law open. We have given that option to you also.
If the matter may just be passed over, because this is a serious.
Then, if the matter is passed over, you please tell SG what has fallen from the court.
Yes, Your Lordship.
If he comes here for handling this matter, it will be commensurate with the cost will be commensurate with his status. Otherwise, we will just in your presence we will keep the question of law open.
Your Lordship, the issue.
Choice is yours, madam. Now. Yeah, we have sufficiently heard you.
Yes.
Yes, we have sufficiently heard you.
Okay, please, Your Lordship.
Lordship, please.
Yes, what is the date of judgment of this order?
20th of May.
20th of May.
Lordship, can you?
1 minute.
Lordship, please.
And what is the date of the notification of the?
14th of May.
So
on the same.
You are saying that it was done only to defeat the purpose of the judgment. So whether the High Court was conscious of the fact that the Chief Justice has reserved 1 minute, where the full court of the High Court of Jammu and Kashmir were aware that the Chief Justice is likely to pronounce his judgment on 20th of May. Dismiss.
Lordship, kindly see page para.
Dismiss. You have clarified in your judgment that this will not be applicable to any process which has already started, and it will be applicable only for next recruitment year.
Lordship, that will.
This will be cost quantified at rupees 1 lakh.
Lordship, I am withdrawing.
Allowed to withdraw.
This is regarding a cap on iron ore mining.
Issue notice.
Your Lordship may, if Your Lordship wants, you can tag it with that Odisha mining matter which is going on. Actually, what happened was that this was going on through an IA.
It is going on before which bench?
Before Justice Dipankar Datta's bench. Okay. It can be tagged with that MA.
Different tag.
Notice to be tagged this one.
Page 322 is Lord.
Give the number. Yes.
MA 18 of 25.
Password. Password.
Sir, appearing in person in this matter. Sir, this is a.
They have granted you on service of the amicus curiae.
Yes.
Why don't you avail of the service of the amicus curiae?
Sir, this is I find this MA I find because I find an anticipatory bail, sir.
Damage that you have grievance against everyone.
Sir, no, sir, I have filed sir, actually what happened, I filed an anticipatory bail application. This court has ordered for VC hearing. At filing online, sir, I filed, but
so made arrangement that you should be provided VC through some court in Tisazari and all that. Who was appointed as the amicus?
Sir, Padmanabhan, madam. Haripriya Padmanabhan, madam.
So you go and meet her. Let her come and argue.
I have to call him. Call her.
Yes, you come through her only. We don't want to hear you. Otherwise, we will dismiss it.
No. Sir, shall I call her now?
You go and meet her and come through a proper procedure.
So my anticipatory bail also cancelled, sir, because sir.
Now you are misusing the indulgence we have been granted to you. Sir. You are coming to Supreme Court now, now and then. And you are having a grievance against everyone. Come to the learned amicus.
Sir, can it be fixed after some time, sir?
It's next week.
Next week, sir. Sir, my anticipatory bail has been cancelled, sir.
Yes.
So they asked me to appear within 48 hours, sir. I have a small baby, sir, a 1-year-old baby, sir. I can't go, sir. Please. My protection may be kindly be given, sir.
That is dismissed.
Sir, protection may be given, sir. I filed an SLP.
You don't want to come through the line, Amethyst will dismiss your petition, right?
Sir, yes, sir. I'll call her, sir.
You can't just call her without she going to the papers and ask her to argue. Next week, Colonel.
This is an SLP against the conviction order.
Yes, we already unfortunately
You
dismissed
know,
it.
I fairly concede it's a DLS matter. Poorly argued on. Your Lordship, only thing I wanted to point out, Your Lordship, there is a common tendency of, roping in all the relatives and, all the, people around in the matter. This is one such case, at least with regard to Kamala Singh and Junnu Singh. Otherwise, all three other, I totally agree. Ikram,
All the witnesses that it is you who commanded Kamala Singh, who commanded the others to.
Your Lordship, this is being added. This Exhortation Act has been added only to include all other peoples. That's you. Your Lordship, long back, Lord Macaulay has also pointed out. This in India, there is a tendency of roping on everyone. So only to that aspect, Your Lordship. I will assist in the best possible manner, even one. Your Lordship, 161. Your Lordship, if Your Lordship will see page 123. Your Lordship, as a matter of fact, no ballistic report is there. As a matter of fact, no weapon was found out. As a matter of fact, cartridges were not examined. As a matter of fact, not even a Naksha Nazri was prepared. And their statements were also not recorded at the time of incident. Everything has been improvised. In the first, they say these people come in the morning, 3 people come. In the evening, they add up another 4 people. To that extent, trial court has been very kind enough to release other 3 also on the suspicion of doubt. Your Lordship, the act is only exhortation, only to, rope in him in.
Thank you, madam. You have done your best.
In that case, Your Lordship, the case may be considered for remission at least. They've been behind bars from last 10 years.
How can there be revision before 14 years?
Lordship, be obliged.
Please, madam. Connected matter, madam.
Connected matter?
Yes, madam. Between the same parties, madam. One by auntie, another one by girl, which is going to settle, madam. I have made a request, madam. They all are in relation. The office report is there.
What is that?
I am great.
Please.
Kindly see.
Once you admit the signature, where is the question of sending it to the handwriting expert?
Why I'm saying so,
So have you denied at the notice stage that this is not your signature?
Kindly.
Yes or no?
No, I am not denying.
Dismiss.
Sir, but can I, this
Yeah,
is
thank
a
you.
case where in MS Narayanan case, this is a case whereby the 3 benches said this is a peculiar case where a security check is there. Here it is a business.
So if it is a security check, then you lead your evidence that it is a security check.
Kindly see, it
is a question of referring it to the handwriting expert when the signature itself is not disputed.
Sir, I am.
Thank you, Mr. Kaul.
Please, Your Lordship.
Petitioner, my lord, the High Court finds that everything is irregular in this. If my lord sees, item 46 is a connected matter where my house was vandalized. Well, because I raised these issues, my house was vandalized. I asked for a fair investigation with CBI. That has been refused, my lord. Therefore, I have challenged that as well.
46. I'm sorry, Mala?
You are hauled up for contempt.
I was, Mala, the same judge.
Just what?
And I have tendered unconditional apology here.
That's what everybody does. That's what everybody does. Malign somebody, then unconditional.
No, Mala, this was proposed, Mala, because the same judge quashed his preventive detention.
My lords, page 24, my lords, your lords may kindly see, there is a direction to cut the trees on war footing. I'm only concerned about cutting of the trees. Let the government take the trees, my lords, confine it. Let that be appropriated by the government, my lords. I'm a lawyer, environmentalist. I'm only against cutting the trees. Very confined to cutting of the trees, my lords. Your lords may kindly see page 24. More than 1,000 apple trees. Now, if it is cut down, soil erosion will happen, my lords. It will have a huge impact on the environmental issues. It can grow like a forest, my lords. It can be confined and grow like a forest, part of the forest.
What will be?
Let the state be. We have also violence.
This matter is pending, but there is a direction to cut the trees and it is going on. The High Court has rejected and it has immediately cut down all the trees. Now about 5,000 trees are cut and it is going on a fast basis.
Government land or private?
This is a government land and the people are encroached upon the land, cut down, they have planted.
We have also filed the SLP in this matter. Malad, White order dated 8th of January 2025, which is not on the record. The Honorable Court had directed the state to auction these all encroached land forest fruit bearing trees, that is apples, Lordship. We started that process, Lordship. Suddenly on 2/7/2025, the Honorable High Court said, no, you fell down all the trees, Lordship.
Why?
Because it is on the encroachment on forest land for years together. We have taken the encroachment back. Now we are in the possession of the land. However, Lordship, we were auctioning those fruits and giving it to the HPMC or whatever agency. But now suddenly the High Court has come with the order.
Cut down the trees.
Cut down all the trees. It will be, it will lead to.
That's only my
issue. What is the number of your SLP?
It's a forest land.
Diary number is this.
41041.
It's a forest land, my lords. Deeply obliged.
You heard with diary number so and so.
41041.
The learned Advocate General with so and so was notice for the state of Himachal Pradesh. Very good. Until further orders, the direction of the High Court directing state to kill the trees shall stand state.
And we will auction all the fruits, Lordship. State will auction.
The state would be at liberty to auction the fruits, auction the harvesting of fruits from the orchard.
We are deeply blessed.
Keep it.
We are deeply.
Lord, I appear for the State Election Commission. Lord, in an ongoing election, Lord, the High Court casts a cloud over the entire voters list to say, just because the enumerators have relied upon a family register, so therefore, Lord, the entire voter list of the entire state is bad. Forgetting, Lord, that the Rule 7, when it says births and register, even a family register is a register of births and deaths. Your Lordship, I've got a compilation of the statutory provisions. Just hand over. Para 7, Lord, I'm sorry. Page 3, para 7 of the impugned order. On the other hand, Rule 7 limits, Your Lordship, I'm sorry. Rule 7 is an enabling provision, Lord. The enumerator can rely upon this, the register of births and deaths. Not that the family register is not a register of births and deaths. Section 4, Rule 4, Lord.
You will issue notice. Notice.
Stay of the.
stay of the impugned order.
I'm grateful.
On the one hand, there are schemes like Pradhan Mantri Awas Yojana to provide shelter to the poor people made on the government land at the government expense. On the other hand, well-established colonies are being demolished, like Russia is doing in Ukraine and Israel is doing in Gaza. My lord, this colony is well established from the year 1985 onwards. People have purchased the land on the sale deeds and they have their houses.
Why would you go to the High Court?
The forest department
If it is originally allotted for agriculture purpose, how could those agriculturists sell it for residential purposes without the permission of the state government?
My lord, due process of law is not being followed in our case.
In 525 order, pre-judge bench order.
My lord, there is no order against us. Only notice is there, which is at page number.
Notice, where is the notice?
Which is at page number, my lord.
144.
145. 144, 145. And the forest department did approach this honorable court. Order is there on page 143. That their petition was dismissed. Their SRP was dismissed. At page number 143, it is there.
Hit 140. 144.
Where is the notice issued to you?
144.
For eviction?
Sorry.
Where is the notice issued for eviction?
Notice is, Lordship, at page number 144, 145. But that was only when they came to demolish the things and we made hue and cry. Only thereafter they have issued this notice. Without following due process of law, this notice is there. At page 144, 145.
Prima facie, it appears that the
My lord, we are actual purchasers of the land by sale deeds.
prima facie, it appears that the division bench of the Karnataka High Court, by its judgment, dated 23rd of July 2019, has rejected the contention of the state that the land in question is a forest land. The SLP challenging the same is also dismissed by this court to be on 19th of November 2020. That we have the matter. We have privacy of the release that if you notice at page 21st of June 2025. Does not appear to in accordance with law. That we have the matter is to notice. Lieutenant of Police, the parties shall maintain status quo as of today.
Yes.
So extension of the learned chairperson's tenure, your lordships. There are just 2-3 things I wanted to bring to your lordship's attention.
Who's appearing for this? Your
Lordships, this was union is not a party to the matter because this was I was appointed a
By
mindless.
how much period?
Lordships, I think about a year would be appropriate. There's one more request that the chairperson had to your lordships.
Yes.
This is with regard to creation of the website, your lordships. Now, with regard to the creation of the website, the matter has been going back and forth, but no ministry is taking any responsibility of releasing the funds. So your lordships may ask the union to
We'll permit you to implement the Union of India as party this time.
your lordships, we've done that. If your lordships may just request the Solicitor General.
But then we have to get someone for that.
Please, your lordships.
We have to get either the learned solicitor or attorney to.
Lordships may say on the next date, I will ask him to be present.
Very good. The tenure of the chairperson, the committee. Is likely to expire on 31st of July 2025. Is extended by a further period of 6 months from today.
Right.
Insofar as creation of website is concerned, request the running amateurs.
So your lordships are.
You offer the petition.
Your lordships, I was appearing earlier. I'm told that it might take a year because 16 high courts, the training program has to take place. I'm just putting it to you.
Extended by 6 months.
As your lordship pleases.
You can again request your application.
Absolutely.
Clarence Singh added a picture. It is also necessary to create a website. However, the game has not been done. As such, some directions will have to be issued to the Union of India in that regard. Pose the matter. The next week, we request the learned Kenya Council to discuss about this matter. Request the land, either the learned AG or LG to assist the court on the next.
Very grateful.
It's very C now. Yes, Mr. LG. One minute. One minute.
May it please, please.
Yes.
49 and 5 are missing. 49 is being taken with 5. Okay.
Lords, I appear for the state of Jharkhand, my lord, receiving a short pass over, my lord.
What state?
How many passports are there? How many passports are there? Passports are done. Passports will be done from item place.
Appears to be some fresh matters.
Millets, I appear in this minutes. It's a case of relaxation, Millets. I am the senior most IPS officer. I had some trumped up charges against me, Millets. Now I have been discharged and the department proceedings also dropped, Millets. And I was given promotion retrospectively all benefits have been restored, my lords. Now, my lords have held in Prakash Singh 3 that there should be a residuary service of 6 months.
Minimum 6
And yes, indeed, it's minimum 6 months.
And once you
6
are
months.
appointed, then you should get a fixed tenure of
On a
2 years.
case basis, my lords have relaxed it. In my case, my lords, there is no contributory factor. Even my junior became DGP and retired. And twice I missed it.
Who is appealing for state of Jharkhand?
Please, my lords, I am appearing for state of Jharkhand. My lords, I am being led by Mr. Sibal. I am just seeking a short pass over, my lords. He's on his legs.
My state is Tamil Nadu.
My state is Jharkhand. I filed a contempt petition, my lord.
What is your case?
I filed a contempt petition. I am the leader of the opposition, and the Jharkhand state has appointed a person who was not eligible, my lord, for appointment as DG. First, my lord, as an acting DG, then, my lord, as a regular DG. So they've been appointing this person, the same favorite person has been appointed again and again, even though EC had removed him purportedly, my lord, because of some misgivings.
I am
for the central government. I am for the central government, my lord.
Yes, Mr. Solicitor.
Ms. Prakash is right, my lord. This is in violation of Prakash Singh judgment.
This has happened by 8 states. We filed a contempt petition against 8 states, including Jharkhand. This habit of having your ad hoc DGPs, your lordship specifically had passed a judgment in this batch saying you will never conceive of the idea of having acting DGPs. What happens is the minute you have an acting DGP, it's like a carrot and stick. As long as you're a good boy, I will ensure that you continue. Now this, the court has frowned upon. You've also given directions that the states should actually have a model police law which will insulate the police from the travails of the political interference. Now, the compliance of those states have to be looked at by your lordships. This is a 1996 petition on which there's a 2006 judgment, in which there's a 2016 contempt. And then we have now still stuck with them. Each of the states misbehaved.
Who is appealing for state of Tamil Nadu?
I pay for AP, not this compliance, just that's all.
Lord, so far as Jharkhand is concerned, Lord, which was just Lord, mentioned by my learned friend Ms. Desai, Ms. Prakash, Ranja Prakash, 5.2. Lord, there is IA 5.2.
He is seeking a password for Mr. Sibal.
Jharkhand, okay. Please, sir.
Let me pass.
At the end of the vote.
Just one thing, Lord. Mr. Prakash Singh had filed 2 IAs. They were directed to be listed on the next date of hearing. One is for modification of this procedure for appointing DGP, because what is happening is that various state governments, as Mr. Shankar Narayan told your lordship, have been defying the orders of this court. And because the procedure which was earlier laid down was UPSC will give a panel of 3 names and the state government will select. Now, state governments don't send the information to UPSC so as to enable them to send the panel, and thereafter the state government ad hoc selects somebody as acting DGP or otherwise. So we have made an application on behalf of Mr. Prakash Singh that this system should be the same for states like the system is for appointment of director CBI in the center. That is, the chief minister, the leader of opposition and the chief justice of the high court, they should be the committee who should select the DGP. And this whole business of ad hoc, etc., your lordship has already frowned upon. So this was one application. The other was, the main case was also directed to be listed earlier, my lord, in 2023. Since then it has not been listed because unfortunately 6 directions were issued in the main judgment. And most of those, or at least many of those directions, have not been complied with by the states. And therefore, my lord, we have been saying that, look, the states should file status reports as to what is the status of their compliance with those 6 judgments, with those 6 directions. So, and then your lordship needs to hear that matter, because this is unfortunate.
It will be required to be heard at.
Yes, I think Mr. Bhushan's application should also be listed. They should all be taken comprehensively. Ideally, my lord, some MI+ should assist your lordships in this, because all the states are parties and their compliance has to be looked at. And we are petitioners who are, pleading with the courts. And
at one point of time, I think Mr. Raju Ramachandran.
For example, if there is a continuous contempt that is being filed, my lord, your lordship may kindly look into it first, my lord.
Mr. Ramachandran is already amicus.
Yeah, the Solicitor General is also saying, Milord, that this is what has happened. There is an evident contempt.
Yes, but the concern for the state of Jharkhand is not here, so. You are 42 is there. That is regarding pertaining to which state? Oxford. Yes, Mr. Solicitor, what do you have to say about your Oxford cadre? He said that you also don't follow the procedure.
I'll take instructions, my lord, and I'll file my response.
So we'll have it on some other day because the policy will have to be uniform either for Jharkhand or for Oxford.
Certainly, my lord, there cannot be any doubt about it.
May I add one sentence, minutes, my lords.
Who is for state of Tamil Nadu?
Since mine is time bound, minutes, if I'm permitted, I'll take out notice to them so that my lords could hear me. Mine is completely unconnected with the batch.
Unconnected means that if this court says that there has to be a remainder of 6 months tenure.
Millets, earlier it was 2 years. My lords have brought it down 6 months.
Minimum 6 months.
6 months.
Because on the
And
last
millets-
date they would appoint.
And Millets, I've just placed on record the orders of your lordships where in fit circumstances it's been interfered with. And Millets, a decade I fought and I came out clean. And twice I missed the opportunity for no fault of mine.
Your serial number?
Senior.
No, 5.
Serial number 5.
Yeah.
Returnable next week.
Great. Deeply.
So contempt, so we'll first, I think.
That formal notices may be given, Milord.
Lordship, in the state of Andhra Pradesh, to the state of Jharkhand.
Yes.
On the last occasion,
Have you received a copy, madam?
I have received copy of Akhil Bharatiya contempt IE number 33773.
That's of the pertaining to Jharkhand.
Notices be accepted by them. They have the copy.
But now you'll have to be relieved. But can you continue to assist him as an ASG? You have to have someone. So ask Mr. Ramachandran whom would you like to have. Keep it in the next week.
Those IAs may also be listed. Mr. Prakash Singh's IAs may also be listed.
Your lordship.
That's the in my case.
Lordship may direct that everybody will serve it on Mr. Ramachandran or his AOR, whoever he appoints. Otherwise, on the next date, he may not have the benefit of whatever is required.
My lord,
That's the in my case, mates.
5.2 copy is already there. It's a case even of an aggravated contempt, not only in violation of the orders of the honorable court, they appointed the president and VP. As a person acting, and then they actually framed the rules, which was contrary and was trying to water down the entire judgment of the Honorable Supreme Court.
Requires all these matters will require some hearing because I don't think that we can.
They will be very serious issues.
My lordship, 2 years we have filed against the state of Andhra Pradesh, my lordship. We are already
Submit notice issue.
at least 2 years also next time.
Notices we issued on all these matters. Except for return of 2 weeks, except Mr. Naidu was for 8 weeks.
In my case, that's 3 minutes I pray.
In fact, my lord, your lordship may issue notice on those 2 IAs also. One is for.
Give me the number of those IAs.
Yeah.
Yes, sir, all these matters.
Any fixed date, your lordship?
After 2 weeks, we'll give it on from Monday after 2 weeks. Then we'll fix up a calendar for some way. To inform all the parties, sir, their applications reply. They were assisting Mr. Raju Ramchandran, who is assisting court as an amicus curiae. दो हफ्ते के बाद रेट
Great. Steve.
My lordship, two ISS filed in same petition, my lordship. It has not listed today. So,
So I have forward.
and also intervention, my lordship. State of Andhra Pradesh also, they have not mentioned.
Let it, so we don't let it happen.
Lord, I represent, my lord, the applicant in 62356. This is an IA, my lord.
Lord, I have filed it, only I'm supporting you. Lord, I have moved an IA on behalf of the state of Maharashtra. Lord, because of the injunction granted, all construction activities, my lord, of the state have come to a grinding halt. And we need, my lord, housing on an urgent basis, my lord.
My lord, there exists no body in the state who appraises any environmental proposals today.
No, there is a Maharashtra, there is a CI, there is CI.
That's the problem.
That's the problem.
Yes,
There is
that's
no
all.
body today.
Lord, pursuant to your
There is
lordship's
CR.
order, Lord, the authority which is CR, my lord, has been precluded from considering this, my lord, and there is a complete regulatory vacuum, my lord. That's the problem which we are facing. So we have filed an application on behalf of Godrej, my lord. 5 of my projects, my lord, over 1,450 buyers are affected. They have their home loans, my lord, and there is nobody to appraise our EC, my lord. We went to the state. They said in view of the state stay order, we can't do anything. We went to the center, my lord. The center also says, my lord, we are bound. So, my lord, ultimately, there is a regulatory vacuum, my lord. If I can just, my lord, place what is the case. But I've just made a one-page list of dates, my lord. If I can just place, my lord.
Because it can't be that there is no body who appraises.
My lord, my lord, every investment is stopped.
Just 1 second. Lord, it's a short point, my lord. May I
Yes,
assist
but
your
I
lordship?
support Mr. Kamar.
Lord, can I just place, my lord? I'll not take more than 5 minutes by the clock, my lord.
The IAs, in fact, that are filed are with respect to note 2, which is with respect to general conditions. But whether
Yes, but then how can there be a blanket stay?
no,
Yes.
there's no blanket stay. There's no blanket stay.
We'll hear it on 5th.
Yes.
Lord's Union has also filed an application for vacation of stay, and the difficulty is because of the broad nature of your lordship's first order. If your lordships have the first order of 24/2/2025, my lords, there is a blanket stay of the 2 notifications, and therefore there are important projects, my lords, across
There
the
are
pieces, national infrastructure suffering, my lords, in addition to private.
Nobody wants to
projects,
stop
my
these
lords.
projects.
No,
Nobody wants to
entire
And- and
developmental
stop the
activity
project. There is no.
has.
It's a self-inflicted problem because they say the entire procedure under Schedule 8 has been stayed, so you don't require an EC for building construction projects, which is absolutely wrong. What was?
We'll hear it on 5th.
As your lordship, please.
My lords,
Kindly,
we
my
have
lord,
to-
consider vacating the stay, my lord, making it subject to the outcome. My lord, entire development activities, at least in the housing sector, has come to a grinding halt.
Mr. Solicitor will hear it because we can't vacate the stay without hearing them.
Please.
Today, in these IAs,
Party, my lords.
Therefore, we are saying that we'll keep them on 5th.
no, even on the last date, they argued for vacation of the stay. Lordships.
No, that's-
Oh, no.
That's incorrect.
Order.
That's incorrect.
No, we did not have.
What objection we can have for hearing them?
I'm not saying that. These
What
applications.
objection we can have?
Will address your lordship.
If they say that it is an ex party, we'll hear both the parties with regard to confirmation or vacation of stay.
But in my case, I am not saying vacating lordships can decide. I am saying, lords, the application has been made earlier to state, thereafter to center. Now center is also not deciding, state is also
Center
Not decide, your lordship's order.
So we'll hear it on next Tuesday.
Yes, madam.
I had a small difference. My lords, I have filed an intervention. I am an organization that had challenged the earlier iteration of this notification, and I have a current challenge pending in the Kerala High Court. Now, my lords, my request was, if that challenge could also be transferred here, we may be able to assist my lords.
So whatever we decide, that will be one.
That will bind Kerala High Court.
My lords,
We don't want to again we transfer those proceedings. Those proceedings will take time to come here.
we will assist my lords.
You assist us.
Yes.
We'll hear it on next Tuesday.
Only
And who is appearing for state of Maharashtra?
No, I am appearing for state of Maharashtra.
What's your good name?
My name is Samit Shukla. I appeared in IA on May 5th.
Statement that in Maharashtra there is no CI and there is no CI.
No, there is CR, my lord.
So
There is no body who appraises because of my lordship.
What is? Can we also have your permission to say something and ask your learned SG?
My apology.
If there is a SIA and SIA functioning, you please get us a notification regarding constitution of those bodies on the next.
Yes, yes, Manoj. Possibly what my learned friend says, there is, he has possibly phrased it wrongly.
Because of the
He says because of the state, there is no body which can grant permission. That's what he says.
Correct.
Yes,
Correct.
Not the submission
He
is
has
because of
he
the
has
stay
phrased
order.
the
Not.
sentence wrongly.
CIA is saying that we will keep our hands off and we are not going to appraise this project.
Next Tuesday.
Very well.
Well, there is SIA. My learned friend says that
Center has to appraise it.
SIA cannot do it. That's what.
Well,
There are several
the center has to appraise
applications
it. There is
pending.
judgment.
One minute, sir. Yes.
As far as we are concerned, the center has to appraise these applications.
Center has to
appraise these applications. Well, it's not.
So
as if
that
there's
is
a
the
legal
modification
vacuum.
we have done.
But then whether the center is equipped
No, my lord.
to do all this throughout the country.
Well, it's not because of this judgment. In fact, there was another judgment passed by the NGT which came up in appeal before another.
Let us hear it on next.
The general, yes.
Let us hear it on next Tuesday.
Okay.
Yes, we'll have it on next Tuesday.
Please, my lord.
Please,
Serial number 2.
Grateful.
Lordship may consider notice on IS and returnable because
We'll consider everybody instead of again if notice is issued, notice is not served, the matter will get prolonged.
My lordship may list all the IS now. That's all.
Yes.
So the main matter, we can argue the main matter.
We are the main matter. Yes. No difficult.
Obliged.
Grateful, man.
Watch out.
Lordship may have the note. Lordships, can I place the note? Lordships have the note. This relates to tea gardens and the payment to workers. Lordships in 2020 appointed Honorable Mr. Justice Sapre as a one-man committee to actually calculate all the dues which are due to the workmen. And for the last 1.5 years, various orders are being passed. Now, I'll take just 2 minutes to just see what is today. In Assam, Lordships passed an order that the state of Assam will deposit 35 crores by 30th of June. They have said that they have deposited that amount. So that part, your Lordships, will come at page 4 of the note, the straightaway to the state of Assam. So that part is complied with. So no further orders as of state of Assam are required as of today. Lordships have page number 3, where the total dues of the workmen was calculated at page 2 minutes. This is the chart of the dues of the workmen. Lordships have the chart. 409 crores was due. Over a period of time, the state of Assam and ATCL paid. Last order, which is at page 3, para 4 minutes. I have extracted the last order. The highlighted portion only is the 6th line. We direct the state of Assam to pay 35 crores to ATCL by 30th of June. Lordships have that. That, because they have said they have paid. So that part of the direction is complied with.
The remaining sum of rupees 38 crore by 26.
26. So Lordships, therefore, this for Assam, no further compliance as of now is required.
Learned amicus get well. By the order dated 24th of January 2025, this court had directed the state of Assam to pay a sum of rupees 35 crores to APCL by 30th of June 2025 and remaining sum of rupees 35 crores by 30th of June 2026. Correct. The learned amicus states that accordingly an amount of rupees 35 crores has been paid by the state of Assam to ATCA. Also, so far as directions to the ATCA are concerned, the APC will proceed to take steps to release the
Yes.
cash in accordance with the directions issued by this. As such, the obligation is to warn the state of Assam as of now stands complied with. The further direction is to be complied with by 30th of June 2026. Insofar as such, matter insofar as state of Assam shall be considered in the month of July 2022.
Grateful. ETCL can file an affidavit about disbursement.
For ETCL, I'll do it, my lords, within. After dispersal will take around 6 to 8 weeks, my lords. I will file it in compliance.
So in Kerala,
So that ATCL,
sorry,
after disbursement of an amount of 35 crore, will file an affidavit detailing out the steps taken by for compliance with the court's order.
for Kerala, only 2 gardens I have directions I have requested. I don't want to take your lordships, it's all there in the note. Page 6 minutes. One Mahavir plantation, page 6 of the note in the table. Mahavir plantation, Milos, in the table was to deposit 20 lakhs by 30th of June as per your lordship's order. Because they have not done so, Milos, is what my instruction was.
I'm just requesting for 2 months time to pay the amount, Milos, because there was because of the heavy rains, crops was not there. And so far as Tamil Nadu was concerned, we were to deposit 10 lakhs. There was some financial crunch, Milos. We have deposited 60 lakhs in the past, Milos. Just one more opportunity I'm requesting, Milos. Within 2 months, we'll deposit the amount.
Let them do that.
Insofar as Mahavir plantation is concerned, it was directed to pay an amount of these 20 lakhs by 30th of June 2025, insofar as these 3 gardens in the state of Kerala are concerned. It was further directed to pay an amount of these 10 lakhs.
So
Tamil
Nadu plantation is concerned.
No, for Kerala, sorry, 10 lakhs. Okay, sorry, I missed it. Yes,
9 lakhs.
9 lakhs.
It was further directed to pay an amount of 9 lakhs insofar as payment to the laborers to 3 gardens in the state of Tamil Nadu are concerned. The learned council states that on top of certain difficulties, this amount will not be paid. Therefore, seeks 2 months' time to comply with said direction. What's the matter? In the last week of September, for compliance insofar as the payment to be made by Mahavir plantations is concerned.
Last thing is only Tamil Nadu, as my learned colleague said, he has paid 9 lakhs. Only thing is one.
He has to pay 9 lakhs.
He has paid, Milos.
I have paid.
That chart, your lordships will get at page 60.
Pay 9 lakhs, he has to pay 10 lakhs.
Yes. So, and for Tamil Nadu, Milos, I was requesting lordship may have it in September. Another report from Justice Sapre is awaited. So that Milos lordships, I'll place it the whole thing for Tamil Nadu in September, Milos, rather than taking it piecemeal.
You have to be careful for other considerations in the last week of September.
Yes, Milos. Lordship may just indicate further report for state of Tamil Nadu is awaited. That's why.
In as much as the further report for state of Tamil Nadu still awaited.
That's all, Milos. Nothing else. It's just
Even in the last from Monday.
September. Yes,
last
because September is vacation, Milos. Sorry. September last week, 23rd September or first week of October, lordships can keep any day.
So we'll have it on 22nd.
22nd, Milos. Grateful. By that time, Tamil Nadu will be complete. I'll file a note for Tamil Nadu. Grateful.
The same matter when Justice Sapre was kind enough to refuse to take remuneration.
Yes, Milos. Yes, Milos. And he said that this should go to the widows who have, yes, Milos. So that calculation is going on. In fact, ATCL has filed a list of etc.
What is ATC?
ATCL is the Assam Tea Corporation Limited. Assam has 15 tea gardens which are owned by Assam Tea Corporation, which is the government of India. Government of Assam body. So Assam, they said we don't have money. So lordships then said that then state reimburse ATCL and pay the money. Otherwise workmen will have nowhere to look to. So that's why, Milos, after hearing the Chief Secretary, Milos, who was present in person, they said we'll do it in 2 installments. 35 crores by June and 35 by next June. And Kerala are private, Milos. So therefore that's all. Grateful.
My lord, due to 1,000 kilometer train journey from Gorakhpur to New Delhi, the 76-year-old petitioner in person became severe attack of heavy vomiting, dysentery and stomach pain and fever. Hence, he is not feeling well. So kindly adjourn the case listed at serial number 23. Kindly fix any date.
So you want an adjournment?
Pardon?
You want an adjournment?
Adjournment, madam.
When do you want it?
After 2 months, so that I may get confirmed resolution.
डेट दे देना 2 महीने के बाद
17 अक्टूबर कर दीजिए मैं 17 अक्टूबर
और if you want any
17 अक्टूबर
if you want any lawyer to be appointed from legal services authority
अब नेक्स्ट डेट को देखेंगे
17th of
24.
yes.
My lord, this is leave granted matter, my lord. And by virtue of an order dated 30th of April, my lord, this was going to be listed within this week commencing, my lord, 28th of July. So my lord may post it on any NMD day, maybe on Thursday.
Why NMD? It's a final hearing matter, so it will come on Wednesday, Thursday.
My lord may place it in Wednesday, my lord.
Wednesday for next week.
My lords, the only request I make is, my lords, that there is a concurrent finding of in favor of the respondent who is the president. For whatever reason, my lord, they are still in control of this particular society. If my lords may
We will hear it on next Wednesday.
have it on the that open, my lords, I shall be grateful because my lords for some.
I on board.
My lord may wait for next Wednesday, my lord.
Deeply obliged, my lords.
Grateful.
Wait, please.
I have been 25 minutes.
This is the review.
The whole batch.
Dheeraj Board. The essential ground that we are raising is that, my lord, should have been heard by a constitution bench as per the order of the court itself in these matters, saying that there is an interpretation of the constitution required and therefore place it before an appropriate bench. Your lordship, my lord, have the order dated 23/1/2018. That's the reference order.
23/1/2018.
Lords, we have some copies for you, Your Lordship wants the reference order. We have copies of the reference order.
Lord, we had filed a compilation of the various relevant orders and the judgments that we are relying upon.
There is already a direction that has to be referred to a larger bench.
Just have a look at para 13, my lord. Your lordship has the order of 23rd of January 18.
This is another.
But I'm handing over a compilation.
One more copy. One more copy.
Paragraph 13. In view of the various decisions of this court, one major issue arising for consideration is whether the eligibility for appointment as district judge is to be seen only at the time of appointment or at the time of application or both. Thus, having regard to the contentions and the materials placed before us, and having regard to the ratio and observations of the cases referred to above, some of which are apparently diverse, we are also of the view that these cases involve substantial questions of law as to the interpretation of Article 233 of the Constitution of India. Therefore, we are of the opinion that this matter should be placed before the Honorable Chief Justice for constituting an appropriate bench. Lord, just have a look at Article 245 of the Constitution. Sorry, 145. (145)(3).
Don't worry. Yes.
Yes.
I'm reading 145(3), my lord. The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question.
What is the of the Constitution?
One 145(3), my lord.
Yes. The minimum number of judges.
Minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution or for the purpose of hearing any reference under Article 143 shall be 5. So for interpreting involving a substantial question of law as to the interpretation of this constitution shall be 5.
Or presidential reference.
143 we are not concerned with here, my lord. So this is for deciding a substantial question of law in interpreting the constitution. So that order that I just read to your lordship said that this involves a substantial question of law as to the interpretation of
Then was it not
233.
brought to the notice of the learned three judges?
I'm sorry, my lord. Yes, it was. It was, my lord. It was. The judgment doesn't deal with that aspect of it. But my learned friend has filed an affidavit saying that he appeared and he said that this has to go to 5. Quite apart from the fact that, as your lordship knows, my lord, subject matter jurisdiction, where, my lord, it doesn't matter if parties object or consent, the court doesn't have jurisdiction, then they can't decide that. This would be subject matter jurisdiction. So that
arguments we will be hearing.
I'm sorry.
Over the matter also.
But anyway, my lord, it was pointed out, there are affidavits before your lordship saying that I pointed this out and my lord, yet it has not been decided, and the 3-judge bench went on to decide the matter. Now, my lord, your lordship, so your lordship has seen the reference order. Please have a look at, my lord, the next order where it goes to another bench, my lord, which is the second. From page 9 to 12, your lordship will find the order of 10th of May 2018 in my compilation that I've just handed over. Which one? Take note. Relevant one. Lord, it's an order in G. Sabita, which your lordship will find.
Yes.
Where is it? You put it or not? Page 13. Where is this? Where is this one? Lord, it's an order of 10th of May in G. Sabita by Justice Chalmeshwar. My learned friend is just finding out the page of the compilation. I'll just read it, my lord. What it says is, the larger question arising from the issue whether the judicial officer who has already completed 7 years in the bar being recruited for subordinate judicial services would be entitled for appointment as additional district judge against the bar vacancy is pending consideration before the constitutional bench.
Page 10.
Yes.
Page 10. I'm sorry, page 10, my lord. The second paragraph. So when another similar matter came up before Justice Chalmeshwar, he noticed that it was already pending before a constitution bench because, my lord, of the reference order which said that this involves an interpretation of the constitution and therefore constitute an appropriate bench. So that is how, my lord, the other courts also interpreted that reference order.
Yes.
Then, my lord, your lordship may have, there are various judgments. I'll just refer to 3 of them, my lord. 2021, 11 SCC, page 78.
Page 16.
Page 16.
Write down what they're saying.
That this is mandatory. That if it involves an interpretation of the constitution, then it has to go to 5 judges. Your lordship has, my lord, paragraph 21 of that judgment. At page 27. As such, we are of the view that such questions do constitute substantial questions of law to be considered by a bench of 5 judges. It is clear from the language of Article 145(3) of the Constitution and Order 38, Rule 1(1) of the Supreme Court Rules 2013, the matters which involve substantial questions of law as to the interpretation of constitutional provisions, they are required to be heard by a bench of 5 judges. In fact, that's what, my lord, the article says. My lord, the Chief Justice was a party to it. Yes. Then, my lord, 1989, 3 SCC, page 282.
29.
At page 29.
What is the
Again, for the same purpose,
No, no,
my lord, if it,
what is the running paper?
the running page in the compilation, my lord, page 29, I believe, my lord. 29, Manjushri Plantations. And I'm reading paragraph 9 of that judgment at page 33. It could not be disputed that the question which is involved is a substantial question of law with regard to the interpretation of Articles 31A, 31B, and 31C of the Constitution. It is also clear that this Act, so far as it pertains to forest land, is concerned, was declared unconstitutional, and it appears that it was because of this that the Act was put in the 9th schedule by the 34th Amendment to the Constitution, so that it is protected by 31B. It is also not disputed that Section 3, which partly was declared unconstitutional, remained as it is, and in this view of the matter, in our opinion, it is a case which would involve a substantial question of law pertaining to interpretation of the Constitution. In our opinion, therefore, it will be proper that the matter be placed before a bench of 5 judges, as provided for in Article 145(3) of the Constitution. Then, my lord, the next judgment is 2005. Yes, but 2005 7 SCC, page 151.
Page 50.
Page 50. And I'm reading paragraph 10. At page 54, bottom.
Yes.
The submissions made before us call for an interpretation of Article 361 of the Constitution and other related issues. It is a case involving a substantial question of law as to the interpretation of the Constitution within the meaning of Article 145(3) of the Constitution. We are therefore of the view that the question whether the governor could be impleaded in his capacity as the governor and whether notice could be issued to him on the writ petitions in the context of the averments made and the prayers contained therein have to be resolved by a constitution bench. Then, my lord, 2013 11 SCC 261 at page 35, very short order, my lord, paragraph 2. You have it? It's a very short order. Page? No, which one are you reading? Faculty Association.
Yes. I think there's only 35 page. We start from 35.
Yes, sir.
So that also, my lord, then just 2, 3, my lord, I won't cite all of them.
You can give a list.
Yes, I'll give a list. I'll give a list, my lord. Now, my lord, once there is a judicial order saying that these cases require
consideration by
of Article 233 and therefore place it before an appropriate bench, that means it has to go before 5 judges. Lord, the law is very clear. 145(3) is very clear. So it should have been placed before 5 judges. Now, Lord, the question arises. In some cases, Lord, people say there are many cases which involve, Lord, an interpretation of the Constitution. Which of them should go before 5 and which can be decided by a normal bench? So, Lord, the law on that seems to be that, well, many cases may require an interpretation, but if there are already judgments which interpret that article of the Constitution, then it need not go before 5. That, my lord, your lordship may have.
You may give a note.
I'll give a note. 2020, 2 SCC, page 595, my lord, and paragraphs are 155, 160.
There is an already interpretation by another constitution.
Yes. So, therefore, my lord, the question is that when the matter came up before your lordships sitting in a bench of 2 or 3, my lord.
3, I think it is decided by 3.
Then, when, my lord, an order was made that this requires an interpretation of the Constitution.
Yes.
So, once, my lord, the reference order itself says that this requires an interpretation
by 5 judges.
It didn't say 5, my lord, to be fair. But yes.
When the language of 145(3) says that it has to be 5 judges.
Lordship, please. So therefore, my lord, it had...
सगळे चुकीचं बोलत आहेत ते. आता मला इतकी संधी आहे.
सबको म्यूट कर डालो.
Just mute.
Malaj, there are 2 judgments of 5 honorable judges dealing with this
issue. Only hear those consuls who are present in the court.
Malaj, I had a slip disc, which is why I can't come. I'm appearing for the High Court. I had a slip disc, Malaj, which is why I'm not there physically. I have a physical condition.
No, you are opposing.
Yes, well, there are n number of judgments, including Constitution Bench judgments, which have decided the issue before your lordship. And those Constitution Bench judgments of 1960, 1967 have been followed by a series of judgments. My learned friend is physically in court with a detailed note, Malaj, containing the relevant paragraphs. This issue, and I agree with my learned friend that if there is a Constitution Bench adjudication, it need not again go to a Constitution Bench after 2 judgments.
So according to you, there is already an interpretation of 233 by the...
Absolutely, Malaj. And that has been followed by 2 and 3 honorable judges in a number of judgments, 1960 downwards.
I have 2 answers to that argument, my lord. Number 1, both the Constitution Bench judgments are in my favor, which is what, my lord, the court noticed in the reference order. Secondly, once a reference order has been made in the case saying that this involves an interpretation of a provision of the Constitution and therefore place it before an appropriate bench, then it has to go, my lord, before 5. Then your lordships were of the opinion that no, the earlier Constitution benches don't decide the matter, quite apart from the fact that I am saying they are in my favor. In fact, I had relied upon them, my lord, when the hearing took place. So therefore, my lord, that doesn't solve the issue. Once there is a judicial order, that Lord reference order of 23rd January 2018 saying that this involves Lord interpretation of the
Article 233, yes.
Then, my lord, therefore, it can't be placed before 3. It has to go to 5. Now, just one, my lord, judgment, that is 2005 7 SCC, and that your lordship, my lord, very pertinently asked, was this pointed out? There are affidavits, my lord. My learned friend himself has filed an affidavit saying that I appeared when the matter was called. I pointed out that this has to be heard by 5 judges, but that was not, my lord, acceded to by the court. And the judgment doesn't, my lord, have any, lord, it doesn't deal with that at all. But quite apart from that, so that is number 1, that it was pointed out. But quite apart from that, my lord, something like this, which is required by the Constitution to go before 5, in my humble submission, my lord, a decision by 3 judges on that would be, my lord, non-est. If your lordship has 2005 7 SCC 791.
Yes. Who is happening for the other side?
To supplement what my learned friend said, where a 6...
So, who are the ones who are opposing?
I'm opposing it. I'm opposing it.
Allahabad High Court, my lords.
Beg your lordship's pardon.
No, who are the ones who are opposing in reference to a constitution?
Not opposing, my lord, but there's another aspect to it which your lordships may consider. My lord, Dheeraj Moore is the one where this is decided, placing an interpretation on 233 1 and 2. What Mr. Bhushan had brought your lordship's notice is an order which is passed in Dheeraj Moore in 2018, when, my lord, the matter was sought to be referred.
By Justice Kurian Joseph.
Yeah, by Justice Kurian Joseph. No, my lord, what the learned Chief Justice at that point of time did, my lord, was to place it before a 3 judges bench. It is a fact, my lord, that it was pointed out that the order of reference says that it must go before a constitution bench. But whatever it is, my lord, it is done. Dheeraj Moore has taken a view. No, my lord, the application where your lordships are now considering is one for an open court hearing in a review petition. No, my lord, there are other matters where the same issue has now arisen. Dheeraj Moore stands in the way, my lord, of the interpretation being considered of different interpretation being given. My lord, when the matter is there before the Honorable Chief Justice, it is always open, my lord, to the Honorable Chief Justice to say that notwithstanding what has been decided in Dheeraj Moore, your lordships would like to consider it by a constitution bench. Because it's a, but then the review as such, my lord.
If the Chief Justice considers that 233 is required to be decided by a bench of 5 judges, then I think all this...
Then, my lord, the review, your lordships could consider allowing the review.
Then the review will have to pen till the decision of the constitution bench.
Yes. Correct, my lord. Or your lordships could allow the review and have a completely different hearing.
Review will be pending that. The review can be heard along with the constitution. It has to. नहीं ये मेरा है क्या sir? Which one sir? Which area sir? This review is alone. He is only focusing on Kerala cases. That's a problem. The review cannot go because you have been appointed, so you have not been presented by him. That's what it's.
Before that, may supplement. For want of space, I am here, my lord. Your last.
What are the views? We'll hear only those who are opposing the matter to be referred to a constitution bench. Is there anyone?
Well, I am opposing. Well,
that we know we have recorded your opposition. Yes. Whether Dheeraj Moore says that it has been considered by earlier constitution bench.
Those judgments are in our favor.
Yes, yes.
May I add one sentence, Mills? May I add one sentence? Mine is the first matter, Mills, 25. Mills, the practical problem here is this. Many judicial officers have been appointed because of Dheeraj Moore, they were sacked, they were reverted. And most of them, again, they're waiting for their appointments. Some of them on the verge of retirement. All these practical difficulties of the Mills. Reviews are pending before my lord.
Just your short notes, 2-3 pages within.
Yes.
Yes. Yes.
No, my lord, the respectful submission is your lordships could review Dheeraj Moore if your lordships find that there are grounds. Then your lordships may hear the matter, my lord, this bench itself.
No, but if we find that it is appropriate that it is decided by 5 judges.
Yes.
Once the 5 judges decided, whatever the 5 judges will decide in Dheeraj Moore will automatically cover.
Yes. Correct. Yes,
Your lordships keep the review in Dheeraj Moore apart.
Yes.
Then decide the other matters in sitting in a 5 judges bench. Obviously, my lord, the review in Dheeraj Moore will have to abide by.
All the other pending matters will get covered by.
That's correct.
Yes. Yes. It will.
Affected directly. All of us are affected
The request, my lord, which we are making is.
All of us are affected, my lord, with the Dheeraj Moore judgment. We are all affected.
So we will consider that.
So they lordship them.
You give everybody give their 3-page notes.
One side
is not practical. Affecting not many judicial officers all over the country.
Serving judicial officers, my lord.
Serving judicial officers.
We are aware about. We are also aware about the ground realities.
Yes.
Yes.
Great. Selected. Great.
The only difficulty is that many of them have been appointed as ad hoc.
Yes.
District judges. We don't get the even benefit of the
Yes, Mr. Gupta, give your note.
Very well, so we'll do that. There are judgments of 3 honorable judges saying it is covered by 5 honorable judges. Justice Chinappa Reddy, Justice. Well, there is judgments where they say it's covered. Yes. And I'll give a little compilation with that, Manas.
I represent the Delhi High Court in Dheeraj. Lordship, just note the procedural history, Manos, how the matter came up before the 3-judge bench. Manos, it was referred, Manos, by a 2-judge bench to the CJI, Manos. The CJI, Manos, gave a direction to list it before an appropriate bench. Then, Manos, it was listed before an appropriate 3-judge bench. And then that bench, Manos, said that it will be listed before a different bench. Well, it's not, Manos, automatically that Manos.
Actually, we will consider that. Yes.
But can we give our note by Friday?
Yes, but not more than 3 pages.
3 pages.
Yes, grateful.
And I'm appearing in 25 and 25.27 for the respondent who succeeded before the High Court. This is a case where, after the interim order was granted by our Lordship's Court in Dheeraj Moore, directing that no further appointments will be made in the quota pertaining to the bar, even if the process was underway. The Honorable Kerala High Court, thereafter, in the teeth of that order, noting the order in its recommendation, recommends the appointment of one particular, the petitioner.
Consider that.
I'm sorry, Lord?
We'll consider it afterwards.
So,
first, let us consider the question as to whether it has to go before the 5 judges or not. Then everything else will follow.
On that, I would only say this. earlier 5-judge bench judgment has been interpreted by the 3 judges. There's no inconsistency in interpretation. No? There's no case made out, and there's no conflict between 3-judge bench judgments.
And the reference notes.
There's no conflict at all with require the reference to a 5-judge bench judgment.
Reference notes the judgment.
Look, also, there's just one point I'd like to make, Mons. Look, just one point I'd like to make.
In item